A letter from the Secretary of State is now sufficient to move forward with deporting any immigrant from the United States. The Board of Immigration Appeals just made this binding precedent in the case of Mahmoud Khalil. Khalil is a Columbia University graduate and a green card holder who was arrested by ICE in March 2025 for his role in pro-Palestinian campus protests. Deportation proceedings were brought against him, and Secretary of State Marco Rubio basically wrote a letter saying that Khalil's presence in the United States posed potentially serious adverse foreign policy consequences. An immigration judge found that that letter was enough for him to be ordered deported from the United States, and most recently, the Board of Immigration Appeals found the same. Now, the BIA is the highest administrative immigration court in the country. Its decisions set binding precedent for every immigration judge in the country. And again, this ruling, officially designated as precedent, says that the Secretary of State's letter is quote-unquote presumptive and sufficient evidence that a person can be removable from the United States. The ruling literally compares that letter to a criminal conviction in a court of law. So Rubio writes that your presence in the United States is bad for foreign policy. No hearing, no criminal charges, no evidence presented. And now, according to this decision, immigration judges are bound to treat that as enough. That is the standard that the BIA just locked in. And Mahmoud Khalil was not the only one targeted in this way. You may remember Rumeysa Ozturk, a PhD student from Tufts University, who was arrested by masked ICE agents on her way to break her fast with friends during Ramadan. Her basis for removal? Co-writing an op-ed in her student newspaper criticizing Israel. There was also Mohsen Madawi, a Palestinian Columbia University student and green card holder who was arrested outside of USCIS at his naturalization interview. Now, internal State Department records that were unsealed by a federal judge in January 2026 show that in nearly every case, the basis for targeting these students was based on one thing: their protest activity. DHS literally noted in multiple cases that there were no quote-unquote alternative grounds for removability. The speech was the ground. So when people say a judge decided this and there was due process, you need to understand what has happened to these courts. Immigration courts are not independent. They sit inside the Department of Justice, which reports to the President of the United States. Since January 2025, the Trump administration has fired over 100 immigration judges. They've purged members of the Board of Immigration Appeals and replaced them with loyalists to the administration. And this is the result that we're seeing. In 2025, if you see in this chart right here that was provided by NPR News, 97% of the published cases by the Board of Immigration Appeals sided with the government. This means that immigrants won just 3% of the time. And former immigration judges have said in sworn statements that the immigration courts and the Board of Immigration Appeals are no longer functioning as neutral tribunals. It has pretty much turned into a deportation pipeline. So no, going through the immigration court system right now is not due process. So if you're an immigrant in this country, it's important to know your rights and be aware that the government has in the past and may try to in the future use your protest activity and your fundamental right to free speech as grounds for deportation. Again, you always have the right to remain silent with ICE, you have the right to an attorney, and always get in touch with a lawyer in order to better understand your circumstances. And people really need to be talking about this case because the whole point of this is to make people go quiet. So please share this information and follow us for more immigration news and information.